Hey, everybody. Welcome to, I guess, a special video of the print report. Pat and I have released two podcasts over the last week and a half in regard to new data privacy laws that will be affecting direct mail and marketing general that's being printed in the United States. And there's a significant amount of people listening to the podcast. There are a significant amount of people contacting us to either say thank you for bringing the information to their attention or saying, oh my God, what is going on here? Which, by the way, I believe is the proper reaction. But honestly, not enough. Everybody should be losing their minds and doing something. And maybe you are quietly in your print companies, but the as far as I'm concerned, everybody should be on, at least on LinkedIn going, what are the associations doing about this? What can I do with my local government and things like that? But to rewind for 1 second, Pat is going to explain to everybody what is going on. And in the meantime, the links to the podcast I'm referring to are either up there or down there, depending upon what platform you are watching this on. Pat?
Right. So thanks, Deb, so much for that. So again, I'm Pat McGrew Group, and what do? We help people do things better. That's the whole idea, is helping people do things better. And because of that, one of the things we watch is privacy law, right? Because privacy law, it impacts anybody who holds data. So we think of it in terms of direct mailers, this is transaction people, this is anybody who holds data in any way, shape, or form. And data is pretty much everything, right? I mean, in one way, shape, or form. So just as a reminder, this applies to anybody who does email marketing. This, it's list brokers. You guys want to be watching out. So the basic roller coaster began back a few years ago when the state of California issued the California Consumer Privacy Act. And CCPA, a lot of people looked at it as the American version of the European General Data Privacy Acts, right? And Canada has a similar act. And the problem is that you can look at it that way, but they're really nothing alike. The European Act is a European nationwide, it handles all of the European Union and the UK and sort of other countries that follow GDPR. California Consumer Privacy Act is a state law enacted in California, but it does a funny thing. It actually it impacts anybody who mails into California or out of California, or if the data ever lived in California, right? So you may not know where your data processor and aggregator is. You may not know where lists originated. Your client might be in California. You could be in Minnesota, right? You never know. So we took a real hard look at CCPA when it first was enacted, and we knew that it was something to watch. And a lot of the transaction printers figured out really fast that they were going to need to make sure that they had all the proper contractual relationships with their clients to make sure they were indemnified in case anybody got annoyed. But a lot of direct mailers didn't. A lot of direct mailers didn't really sort of see the light at the end of the tunnel and go, oh, wait, maybe we should be paying attention. A whole bunch of other states sort of got on the bandwagon and said, oh, we want a privacy law. And some of them cut and pasted pieces of the California law. Some of them decided to roll their own, right? They did a whole bunch of different, there were a lot of different approaches. The net result of this is that we can wind up with 50 states plus territories worth of privacy laws, no two of which match, and which have different layers of regulation in terms of who holds data, how long they can hold data, if they need an opt-in to hold the data, if they need an opt-out to hold the data, if a consumer can sue directly, or if it has to be done by an attorney general in a state. I mean, every dial and knob and lever of difference exists across all the states that are looking at it. So in the middle of all the fun, California decided, oh, gee, we didn't really like our original version. We're going to change it. So they then enacted CPRA with a whole new set of requirements. Why CCPA to CPRA? Very simple. They got a lot of letters, a lot of briefs filed by lawyers, a lot of people, a lot of complaints saying, oh, this doesn't work, this doesn't work, this is a problem. And so they went back and revisited some of the pieces of the bill to reorganize them. Now, is it perfect? No. Does it make life better for list providers, brokers, direct? No, it really doesn't. It just changes a bunch of things that now you have to look at. So what's the net result of this? Well, California, Oregon, Washington State, New York State, most
Nevada.
recently, Colorado and Nevada are the two most recent signers, all have now enacted legislation that touches this situation in some way or form, and no two of them touch it the same way. There are another 20 plus states that have laws that are in process in their legislatures. A lot of this stuff stalled last year because of COVID, right? Legislatures didn't meet in person. They got involved in dealing with all sorts of other things, not privacy. But now that things are opening up again, this is all back on the docket. Now, these are all state. So somebody said to me just the other day, well, it's state-based, so it really doesn't impact me because my business is in North Carolina and I live by North Carolina law, and I understand that you think so. Here's the problem. If
Yeah.
you mail into
Right.
another state,
Right.
the recipient who receives that piece that you send to them is bound by their state law. And so if you start looking at all the places you mail, right?
Right.
It was the same problem we had originally with American print providers mailing into Europe, where they felt like, oh, do I have to do
Right.
GDPR? Do I
Right.
not have to do? When the answer is you do.
And
So,
and a couple of years ago, we discussed this on the podcast, the Canadians came to everybody on their mailing list and said, hey, we have these new laws and we need you to opt in. And they basically
yeah.
gave you 3 chances. And by the 3rd chance, they opted you out. Now, I'm not sure we actually mentioned what the effect of this process is, which is basically if you mail something for on behalf of a client supplied list, or if it's even possible to buy a list anymore, and those people on that list did not opt in to receive printed materials from your customer or you, if you're mailing
For any
your own,
communication,
if you're
it's
mailing
print
your
is one channel, email's another channel,
right, but let's
apps
just
is
talk,
another
let's
channel.
just focus
But
on
print,
print
yeah.
for right now.
Yeah.
The print shop is liable for a data
Can be.
breach.
So let's be really careful here in how we say it. Could be. It depends on the nature of the law, the nature of the state, and how the states are going to, all these things are going to be litigated, right? We know
Yes.
that there's going to be lawsuits filed. There are people who live just to file
Right.
lawsuits.
And just so you know, in part 2, we actually did speak to Dr. Linda Freed, who
Right.
is, maybe explain who she is, because she brought some legal, I don't want to say
Right.
advice, she brought some intelligence to the conversation.
Yeah. So neither Deborah or I are lawyers, but I did bring Dr. Linda Freed, who is a professor at the business school at the University of Colorado and holds multiple law degrees. So she's one of these people who tracks law like this. She's filed amicus briefs with the courts. She's got a lot of standing in this space. And one of the things we were really concentrating on is the laws will be different in every state. And that means that you as a printer need to be coordinating with your legal advisors. Now, not every printing company has a lawyer on standby or on speed dial, and I get that. But you're going to want to find legal help to help you review your contracts with your clients and to make sure that you're indemnified. And Linda was very clear about this. What you're looking for is to the extent that your state's laws will allow it, you want indemnification from things like requiring an opt-in at every step in the supply chain. There was a sense that if I'm a printer, it doesn't really involve me because it's my client's problem. It's their opt-in, it's their customer, it's their data. The problem is that if the data lives in your site for any period of time, you've got some liability and risk management that you want to deal with there as well. So you're going to want your legal team to look at your business and the state where you do business and the clients you do work for to find out what it is that you might need to do or change in your contracts,
Right.
and how you, and even how you're handling data. And the other thing we suggested is data hygiene would be a really good idea right now. Go looking on your servers to make sure you're not sitting there with like mailing lists from 10 years ago,
Right.
data from 5 years ago, heck, data from last year that you have no business maintaining on your server, because that's another place where um, there are all sorts of people. It's sort of like ambulance chasers, but they're just,
Yeah.
litigation chasers. They just love litigating. They love looking for a reason to find someone to sue. So is the average mom and pop shop or the average franchisee a target? They wouldn't be a direct target, probably because the monetary amounts wouldn't be high enough. But if someone got annoyed, it wouldn't stop them from finding a lawyer happy to file a suit for them.
Right. I mean, it's really important that, and to your point, if you don't have the resources, the industry organizations, I will keep
Yeah,
I will keep saying this left and right. Now is the time to join them. Now is the time to, ask them what they're doing about this. And perhaps there's a way of pooling resources and pooling information. The other thing I wanted to mention is that what I have gathered from our conversations is that this isn't a matter of data security, how you're securing the data. It's
no.
a matter of the fact you have the data and how did you get it? And how did your client get it? And did
And did they
the
have the right to
person
have it,
have
right?
permission to have the data to
Yeah,
pass along with you? And it
yeah.
actually started through collection agencies. If you think about it, there's some hourly worker sitting there somewhere on a phone bank trying to get you to pay, that knows your bank, your financial information, your bank account, how much money you owe. And somebody got a little upset about that. And it snowballed into, well, hold on a second. We can't actually stop it here. We need to move forward. But the other thing I just wanted to clarify, or you can further clarify, is that this does not affect legal documents. This does not affect healthcare statements and things of that nature, correct? That data is allowed to be had.
Right. So remember that if for transaction communication and regulated communication, there is a relationship and there is a contract in place, right? That says I can communicate with you, you can communicate with me. All of those things are good. Now, the requirement in those situations is you've got to have auditable security, right, for that data. What we're really trying to get everyone to think about and opening the door to is, if you're a direct mailer, a marketing mailer, somebody who has never dealt with transaction communication before in your life, and you've always just assumed that if somebody gives you a mailing list and says mail to this, or if you buy a mailing list from a reputable dealer, that you have the right to mail to it, that's where changes may have already happened or will be happening sometime in the next year to 24 months as states start rolling out their privacy legislation. If you buy mailing lists and then you kind of sell those addresses on to your clients, you're going to want to find some way to prove that it's okay for you to have those mailing lists. That means whoever your list broker is, you would want to be asking them for opt-in information,
Right.
and you'd want to be working with your legal team to figure out what your obligations are for holding that data and what risk management you need to do. If you are somebody who only ever takes, mailing lists from your clients, you're not done. Now you need to go back and make sure that you're indemnified from using that data to do these marketing mailers. And for my money, I would want to do that no matter what state I was in at this point,
Yeah.
because your mailing list, I mean, it's
You
rare to
never
find a
know when you're
mailer that
gonna,
only mails next
yeah,
door, right? I mean,
exactly.
they
You
mail
you never
everywhere.
know, right? I
Yeah.
mean, it is. it's really important to understand what we're talking about here. Data-driven marketing, variable data. I mean, your digital press is about to become a $2 million paperweight if you can't use data.
And we've been preaching data-driven marketing for years, and it is not the end. Let's be really clear, it is not the end of data-driven marketing. What it means, it any more than GDPR was the end of data-driven marketing in
Okay,
Europe.
but
What
hold,
it
hold on
is
one
you've got to
second.
draw the box around it.
Yes, and I agree with you. It's not the end of it. However, Dr. Freed did give an example with Apple, that
Yeah.
Apple recently went back, and this is kind of what has to happen. Your customers, the brands you work with, whoever it might be, have to go back to everybody on their list and say, hi there, we need you to opt
Get an
in,
active opt-in.
and we
And
need
that
you
was
to opt in to get printed communications as well. Now, by the way, someone could opt in to only get printed communications,
Yep.
only get electronic, don't get anything, whatever it is, but that's what Pat is saying. All the legal
and it's the
stuff comes
difference
in.
between.
Yeah, let me just finish. Well, that's where all the legal stuff comes in, because how do you prove that those people really opted in or didn't opt in when someone gives you a mailing list? Well, we were talking about Apple, because this is really important. Apple went back to their customers for some reason and said, we need you to opt in for something. And Apple got 7% of people to opt back into whatever.
Yeah.
That was it. 7% for Apple. These are loyal, rabid people, usually with Apple products. If they could only get 7%, how many people can the landscaper get? I'm just saying, like the dentist that you don't use, I mean, think of everything that supports the mailing systems. I'm not offended by getting information from a dentist I don't use or a vet I don't use. I actually think of it as
some people
backup information. But the problem is, somebody wants to know, how does anybody know to mail this to me at my house, or that I have a cat and not a dog? And that's what they're getting upset about.
So there's two things here. So one, if you serve landscapers and nail salons and dentists and all those people, remember that EDDM could be a really fabulous product for you to offer to them, because it is unaddressed mail, and that could be a way to get your opt-ins in certain neighborhoods and in geographies, right? You send it out, maybe the postcard or the brochure or the menu or whatever it is, and you say, by the way, if you'd like to receive more great offers from us, hit this QR code,
right?
Text this number, however you want to handle the opt-in. And people have done that for years, and that is still an extremely valid thing to do. The challenge is for people who have a relationship, but have maybe they have multiple products that they sell. And the way the things seem to be laying out is, if you have permission to talk to a customer about the product that they bought, and that might be warranty mailings, it might be reminders to renew warranties, all those things, your car's due for an oil change, you've got a relationship there, and it's likely in that relationship, in your contractual relationship there, or in some other work that you've done with them, you've somehow given them permission.
Yeah.
The trick is, if they then turn around and they try to sell you something different. The car dealership tries to sell you a house. The nail salon tries to sell you a telephone. The local mobile phone store tries to sell you a different brand of telephone than the one that you have. Those are the things that would come under the guidance of a lot of the new legislation that's being considered. So that's where you, as a printer, you want to look at who your customers are, who you serve, how the data comes in, and you want to have your legal team look at what it is you have in terms of contractual relationships and obligations. You are absolutely right. You need to be talking to your associations. If you are a member of any of them, Volume Mailers, ING, any of the printing associations, and there are dozens and dozens of them, talk to your group to find out what their recommendations are for handling it. Make sure they have someone actively looking at what the ramifications are for your group. See who, maybe a lot of these organizations have lobbyists. make sure those lobbyists are aware, but also remember these are state-based regulations. Every state is going to be different.
Right.
And that is where the risk comes in, because every state you mail to, it opens up a risk. And the calendar for implementation, like the Colorado passed their law a few weeks ago, it becomes the law of Colorado in 2023.
Right.
And when you start looking at some of the others, it's in as early as later this year. Some are in 2022 that have already been passed. Some are, and so anything that's passed this year probably has a 2023, 2024 timeframe.
Yeah,
It's going to be in our lives for a while.
it is. And this is the moment to really coordinate and collaborate with your customers and get educated as much as you possibly can on the subject matter. Go ahead, start having conversations with them. There is some time to get this right so that you don't get caught up in any of this. And Pat and I have, have two podcasts, either up there or down there, with that extends this information. But we just really wanted to, put a video out there, because sometimes people look at videos, and if they were going to do that, and this was a way that we could just say, hey, we're just trying to let you know that there is something coming, that if you touch client supplied data for marketing mail or emails or communications, to your point, the bigger picture here, digital marketers too, retargeting, remarketing,
All
Bye.
those things.
by
Yeah,
retargeting and remarketing, unless I've opted in to be followed around with
exactly.
ads. This is about to disrupt everything. However, to Pat's point before, Europe is still there. They're still marketing to people. Canada is still there. They're still marketing to people. By the way, we're looking for anybody in European Union or in Canada who's been through this and is willing to talk to us about how that they have addressed this. It seems to be a sensitive subject, but if there's anybody out there that is, can give us some insight
Their
into.
experience gives some tips and
We're not
tricks.
looking for you to lay out, this is the 10-step process we did. We understand that that could be a problem, but we just want to talk to someone who's actually been through it. So if you have, leave a message in the comments, wherever you're commenting. Please listen to the podcast. Connect with Pat. She can help you with at a McGrew group. Connect with me. I mean, I'm pretty much just a conduit for information at this point. I'm not a lawyer. I'm not the McGrew group, but I am taking on the role of industry alarmist, because Pat passed on that role. I was like, oh no, I'll be the alarmist, because education, as long as you educate yourself and you prepare, there's some time to prepare. You won't get caught up in, oh my God, I can no longer print for people, or worse, get fined. And then Dr. Freed did say it's criminal and civil.
Yeah.
So there's two things going on. Plus there's going to be a federal law eventually. So please listen to the podcast, get in touch with us. Thank you so much for your time. Any final words, Pat?
Find out who your local congressperson is and write to them and tell them that you need to be included in their thought process as they are starting to think about what they're going to vote on in their own state legislatures.
Yeah, state and federal too, because this is this federal privacy stuff is very big in federal too now. So thanks everyone for your time. Good luck, print long and prosper.